who made that horrible decision to keep Terry Boyette out of her home and leave the squatter in it. And this isn't an argument about whether this person was a squatter or not. This person forcibly entered, sold her belongings out on the front door, and your member of your association let that person stay in the home through the holidays and not take the squatter out.
Okay, let's talk about the actual facts of this case. The allegation here is that a property owner was the victim of a squatter who took over their property and wouldn't leave, and that it took months, almost 6 months, to get that squatter out, and the damage done and everything else cost this person almost $150,000. This story is patently untrue, and it is the basis of a new law in the Texas legislature that they are trying to pass, which really has nothing to do with squatters. It really has to do with kicking out normal tenants without trials or due process and defunding legal aid. Now, here's the actual petition filed in this specific case by Terry Boyette. And you'll see in here that it says that there was an oral agreement. Now, that's not a squatter. A squatter doesn't enter by oral agreement. A squatter enters with no agreement. And the grounds for eviction are holding over. A holdover tenant is a person who stays beyond their welcome. So if you have a 12-month lease and you didn't move out at the end of the 12 months, you might be a holdover tenant, and therefore you could be evicted for that. But that is not a squatter. In this next document, and I think this is important, we're looking at a request for alternative service. And this is a document filed by the constable who is charged with serving the citation, which is the notice to the tenant that they have been sued for eviction, and tells them when to show up to court to defend themselves. Now, you'll see here that service was attempted twice. On November 14th, 2023 at 1:41 p.m., there was one attempt, and the next day at 8:30 a.m., there was a second attempt. There was no attempt in the evening, and you might think to yourself, well, aren't most people at work at 8:30 a.m. and at 1:41 p.m.? Yes, that's correct. But that's when service was attempted, and since the person wasn't home because maybe they were at work, we've requested from the court to do alternative service, which is possibly a way that the tenant might never receive the notice. And in this case, this service was made by taping the citation to the outside of the door, where maybe it flew off in the wind, maybe a neighbor came by and ripped it down and the tenant never got it. Who knows? It's impossible to tell. However, in this next document, we can see that whether this person got the notice or not, they did not show up for the court hearing, which could indicate they didn't know it was happening. They failed to appear. The box is checked right there by the court, but that's not the important part of the story. The important part of the story is that the allegation is that the judge decided not to evict the tenant over Christmas and let this squatter keep the property instead of giving it back to the homeowner. But on December 5th, in this document, you can see for yourself that the judge granted the eviction on December the 5th, 2023. Now, evictions don't happen automatically. Just because you get a judgment, as the landlord, you have to go back to the court and say, I won. Please give me a writ of possession so that I can go and evict this tenant. And in this next document, we see where the landlord finally did this on January the 19th. Almost 2 months later, the landlord had won the case on December 5th, but didn't ask for the writ of possession until January 19th. And keep in mind, this isn't just some ignorant landlord. They're using a service, Texas evictions. Who knows the rules? But they didn't even make the request until almost 2 months later on January 19th to actually get the writ of possession. So this is not the judge's fault that the tenant got to stay through Christmas. This is the fault of the landlord who never asked for the person to be removed until the end of January. And finally, in this last document, we see the actual writ of possession, which was issued and signed by the judge on January the 29th, 10 days after it was requested by the landlord. Now, this was not a case where the tenant played games or I'm sorry, the squatter possibly played games and used the courts and the system to overstay their welcome. This person never even appeared in the court. They didn't file any documents. They didn't show up for their hearing. This is simply a case where a landlord screwed up. They didn't follow any of the rules. They didn't take advantage of any of the existing procedures. And that's why it took months and months and months to get this person out. That is not the fault of Texas tenants. And we should not be passing laws that hurt every tenant in the state of Texas because of one false narrative that was told in a Senate hearing.